Hello and welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the Idaho 4 case, people of the state of Idaho versus Brian Kohberger. And in order to get you caught up in the event that you've never familiarized yourself with this case, I'm going to give you a little bit of a primer of the facts of what this case is all about, just in the event you've never heard of it, which would be, you're into true crime, that would be unbelievable to me, but there may be people, you never know. So on November 13th of 2022, University of Idaho students, Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin were stabbed to death in their off-campus residence in the small college town of Moscow, Idaho. Unable to identify a suspect or a motive, Moscow PD, along with the Idaho State Police and the FBI, launched an intensive search for the killer that lasted almost 7 weeks. The murders left the community in fear, drawing widespread media attention that placed Moscow, it's Moscow, not Moscow, and its residents under an intense national spotlight. Misinformation was rampant on social media, with armchair detectives wrongly accusing several individuals of the crime, leading to harassment and admonishments from law enforcement. During the investigation, law enforcement discovered a leather K-bar combat-style sheath under one of the victims. Testing revealed a single source of male-touch DNA on the sheath's button snap. This DNA was one of several factors that led investigators to Brian Kohberger, a 28-year-old criminology graduate student at the Washington State University, a mere 12 minutes away from Moscow. Police from Pennsylvania State and the FBI arrested Kohberger at his parents' home in Chestnut Hill Township in the Poconos on December 30th of 2022. He faces 4 counts of first-degree murder and 1 count of felony burglary, and he is pled not guilty. So what we're going to do, if you guys are not up to date, what's been going on in this case, there's been a lot of motions filed in the case, just a ton of back and forth between the defense and the state. And one of the most recent filings was the motion for a change of venue that was filed by the defense in this matter. And Ann Taylor is the defense attorney. And back, I believe it was August 29th, 2024. And just so you guys know, one of our very own wonderful Spitfire, who's just an absolute fan member and who's really just an amazing human being. She has created a template for, I don't know if you guys remember, I had asked if there were any fan members out there that wanted to get involved, helping collect data, do case summaries, do hearing summaries for things that they want to hear about. And Spitfire created, number one, the template that we intend on using with members that do want to get involved. And she happened to prepare this very first template on this very hearing. So it was very good timing on her part in terms of getting this done. What I just read you, that little opening salvo, was written all by Spitfire. So great job there, Spitfire. And she goes on to really summarize the entire hearing itself. It's really a masterclass on how to do a template for me to read, to give you guys an idea of what went on in that hearing. And then what we're going to do is we're going to read the order that came down. That was pretty big in terms of whether or not to move the case from Latah County to another county somewhere in Idaho. I'm not going to read through Spitfire's entire template because it's almost as long, if not longer, than the order. But I do want to give you just kind of the basics of what happened at that hearing. So that way, when I'm going through the order itself from Judge, yes, that is his name, Judge, uh, you'll have a better understanding of what it's about and why it matters and why he ruled the way that he did. So, kind of the summary is that the defense, like I said, filed a motion for a change of venue from Latah to Ada. That's where they wanted to go, and it was due primarily to media coverage. The prosecution, of course, opposed the motion, and the reason you're I shouldn't say never, you're rarely going to find a prosecutor's office wanting to move a case out of the jurisdiction wherein the crime took place. Um, it's an advantage to them to have it there. Typically, pretrial publicity is an advantage to the state, so they're not overly concerned with the fact that defendants are tried in the press. That's all in their favor. So you're typically going to see defense attorneys filing these motions, arguing that they can't get a fair trial for their client in whatever jurisdiction it may be in due to the media coverage of it. And anybody that's followed the Kohberger case, which really was national, went far beyond the borders of Idaho. It was a huge national story. It still is. Like anything, any case where you have kind of lulls and you're in that period in between arrest and trial, where you're in the motion filing stage, the media will pipe down a little bit until the thing gets started back up. But I have zero doubt that once this case gets moving back again in terms of trial, that it will pick up right where it left off in terms of media coverage. It'll be just a madhouse, just swarm. The courthouse will be swarmed. So um, I think it was a valid motion. And I think obviously with the result of that motion, with respect to what the judge did on it, I think that bears itself out. So, Ann Taylor, as I said, is the defense attorney who filed it, um, and she presented a lot of demonstrative evidence at the hearing. There were hundreds of slides that were used in order to give the judge a firsthand account if he didn't already know, which he did. He understood the media pressure and the intense media coverage on this case. Um, but she presented those at the hearing because obviously she's got to get them in the record. And then she had occasion to call several witnesses. She called a gentleman named James Todd Murphy of Truth Scope. And Mr. Murphy had 30 years experience. He developed a process for comparative media analysis back in the 90s. The defense had hired him in 2023 to look at an extreme amount of media coverage and its impact on the community. And he tracks specific topics such as names, et cetera, associated with the case, and builds a search query to create a data set for his team to analyze. They don't necessarily dive into the content of the data itself. However, they don't track anything illegal or consider streaming channels. They are able to distinguish area due to metadata when a story runs, how often it runs, and the type of media. So TruthScope ended up analyzing 1,360 media stories between January of 2023 and July of 2024. Nearly 40% of the coverage could have been seen in Latah County, uh, though the county though the county only accounts for 2.7% of Idaho's population. So more than 34% of the coverage could have been seen in Ada County, which has 26.42% of the state's population. So it's substantially larger. Um, he also testified that moving the trial to Ada could dilute media exposure because of the number of stories divided by the number of people eligible for jury service is fewer in that county. Meanwhile, potential jurors in Latah are exposed to far more coverage. So the fact is, his kind of ending analysis was that the story has legs with a quote, quick uptick and slow decay. The coverage increases but wanes slowly. Interest will likely continue even after the conclusion of the case. There's a greater interest in Latah County. Over the long term, people in different cities in Latah County have an equal chance of exposure. And then he was crossed by Ingrid Beatty by the state. He was then redirected. The defense then called their next witness, Dr. Amani El Alayi. I don't know if I'm pronouncing that correct, but Dr. El Alayi or Alayi, one of the two, is a professor at Eastern Washington U, and she studies how people interact and influence each other relative to social situations. She was there in a capacity as a consultant, testifying based on her expert opinion and experience in the field. Her research focuses on how people influence others to purchase things or donate money, and on social cognition, how we select, remember, and interpret social information. She has taught since 2002 and has published 15 plus articles on social bias, how we overestimate ourselves, and bias against people, groups, businesses, and etc. Um, and she testified to the following: that there's reasons for pretrial bias, there's peripheral route processing. These are quick decision shortcuts, like oh my neighbor has that car and they like it, I'll get it. People consuming media often process it peripherally because they're doing other things. They're processing it superficially. Absorbing information this way might create human bias. There's also authority influence. When people have status, expertise, power, etc., we assume they're accurate, but authorities can be wrong. They're humans who make mistakes. Even minor indicators of authority, like height, can have an effect. People will do things and take things so far that they contradict their morals. Authorities can influence people in areas beyond their expertise, such as letting a doctor influence your relationship. We take it too far. In Moscow, the authority figures are known and trusted in group members. And then another subject matter she covered is classic conditioning, associations between things that are cause reactions, developing a response to stimulus. It could be your alarm clock. You associate the noise with waking up. You could develop a response to a person because you've connected them to something through repeated pairings. It doesn't even take that many pairings. Studies have shown that this can happen in minutes. People can't help but make a negative connection, even if they don't think Mr. Kohberger is guilty. A connection can't help but be made by potential jurors. And then finally, emotional and motivational influences. Fear inducing messages affect how we process information. You start to have an agenda with new information. When you're angrier, you're more likely to be punitive, which means you want to punish. When angry, you're less likely to pay attention to defense arguments. There's motivation to feel like the police have the right person. And that sigh of relief that people feel assumes he's guilty. Any strong emotions can affect information processing. And then, and Taylor asked the question, what happens if we seat a Latah jury and these biases are there? And she answered, well, there's going to be confirmation bias, and this confirms our expectations of things. The need for predictability can causes us to distort reality. Once we develop an expectation of something, everything goes through that filter. We talk about an emotional filter. This is a cognitive filter. And she also said that there would be selected attention. This can affect how you take in information, taking it in a distorted manner. It can cause us to change information to fit what we think. Our recall is distorted. She also testified that there could be belief preservation, and this is an extension of confirmation bias. Beliefs are often persevere in the face of contradictory evidence. Confirmation supplies us with a filter. If people provide contradictory evidence, the other person will sometimes cling more closely and double down on that belief. Once you've formed something, it tends to stick, which is what I'm saying all the time. People might even get more aggressive about this initial opinion, the double down. Once you've decided something, your decision grows legs of its own. And then finally, cognitive dissonance. Uh, and this is an uncomfortable feeling that happens because of inner hypocrisy. We like to prevent that feeling. Jurors might experience dissonance if they begin feeling the defendant is innocent. They might experience an inner clash that leads them to distort reality. Even if they thought that he was innocent, there could be a part of their brain convincing them that he isn't because of loyalty to the community. So then Taylor asked her if they can fix it. And she says that I would love for that to be the case, but I don't consider it feasible. Look at the research. Retrieval cues can make some of these memories more conscious. A juror might not report that they knew something because they didn't remember and don't have knowledge of it at the conscious level. Then there's self bias. We overestimate ourselves and believe we're better than average. People think that they're accurately evaluating themselves, but they'll say that they're less biased than they are and can overcome bias. We cannot accurately report our own biases. People who are more biased are the worst at estimating their own bias. They often believe they can overcome it and overestimate how much bias they in fact have. Then there's our cognitive capacity to overcome bias. When we try to suppress thoughts, we actually think about them more. To not think about something, you have to think about it to catch those thoughts. That is the thought suppression rebound effect. And the media influence still has an effect. That right there reminds me, I can always bring everything back to the Big Lebowski, but that's the scene where, if you know the Big Lebowski, where Jeff Bridges, the dude, is standing there with uh, I forget what the character's name is, the missing woman who's painting her toenails, and he asks him to, something very vulgar, and he's like, "Well, what about him?" Who's a guy floating down in the pool, and he says, "Oh, he won't care. Um, he's a nihilist. Nihilists don't care about anything." And Jeff Bridges' retort to that was, "Oh, that must be exhausting," which goes exactly to that point. In order to not care about anything, you have to work so hard to not care about anything that it would be mentally exhausting. It's the same concept as that. Um, so then she was crossed by Vince Beatty, and then Taylor redirected her. The defense then called Dr. Brian Edelman, and he was the jury consultant, I think, who caused the big stink initially when the information that was contained within the actual survey that went out made it in front of Judge. He kind of lost his shit, was pretty upset about it at first blush, and then calmed down considerably when he was able to reflect and heard some more argument about it. So he's a trial consultant who helps with jury selection, juror questionnaires, voir dire questions, mock trials, etc. He also testifies as an expert witness on the impact of pretrial publicity and whether due process is undermined by media coverage. People consult him on change of venue, and he examines the adequacy of voir dire to determine what jurors know or knew. He's done it nationally since 2011. His background is social psychology and the law. Sounds like me. Researchers or he researches the death penalty founded trial innovations in 2011, and he testified in more than a dozen states. So he ends up discussing social science literature and the impact on pretrial publicity on juror decision making, publicity analysis of the extent and the nature of the media coverage, and its impact on the jury pool, and jury selection in cases with extensive pretrial publicity, their unique challenges, and is voir dire a sufficient remedy. He then gave an example. In a normal case, like a car accident, people might have the general attitudes about drinking and driving, but they don't have information about this person that's well developed. In cases like this, people come into the courtroom with case specific attitudes that are well developed based on emotional information or evidence that they've already seen and heard. There are no blank slates when hearing evidence. They are just conforming with what they already know, as opposed to jurors who don't know anything and are learning and building attitudes as they go. All right, so um, he really was he was a really pretty impactful, I think, witness in terms of um, what he brought to the table in terms of educating Judge on just a lot of things that I don't think that he was necessarily familiar with. I mean, to be honest, I don't know that like I could say with pretty much 100% certainty the Judge had never had a case this size, had never had a case that had this kind of publicity surrounding it. So basically, everything that he was dealing with was first blush for him as a judge, too. I'm sure. It's not to say that he hasn't had some serious cases, but this was a different beast. Um, so he goes on, and Taylor starts questioning me and said, so Ann Taylor asks, what are you looking for when you're deciding to do a survey? And he says that every case is unique and he looks at coverage in the local area. Now, he said that articles published in the Moscow Pullman Daily News and the Idaho Argonaut from November 13th of 2022 through June 23rd of 2024. So in 2022, there were 67. In 2023, there were 130. 2024, there were 43 articles printed for a total of 240. And that's in two relatively small newspapers. Okay. Um, he then compared 16 cases with populations between 27,500 and 62,000. The median number of articles was 85. Change of venue was granted in 12. Change of venue granted in 78% of cases with more than 80 articles. And Kohberger's 444 articles in population of 39,872. Information was spread through social media, disinformation, details, rumors. He went on Facebook and searched for the Moscow murder. And the results revealed a lot, including a remarkable number of groups discussing the case. Um, so they then keep plowing through, and they start getting into the methodology of doing the surveys. And it was a random digit dial telephone survey, which is the same thing that we did in the Garcia case back in 2016. I wish I had this guy as my expert back then. He might have convinced the judge. I don't know. I don't think there was any convincing anybody out there of anything. Section one was eligibility for jury duty. Section two was criminal justice attitude. Section three was crime or case awareness and prejudgment, and four was demographics. So he tells them there are no wrong or right answers. It's not a sales call. They call 3 times at different times of the day to try to get someone on the phone. People can say that they don't know the answer to a question or decline to answer. They surveyed residents of Latah, Ada, Canyon, and Bannock counties. So the percentages of responses: read, seen, or heard about the case, 98% in Latah and 93 in Ada. Followed the case somewhat or very closely, 68% in Latah and 58% in Ada. Believe Kohberger is guilty, 67% in Latah and 68% in Ada. Believe he's definitely guilty, 25% in Latah and 22% in Ada. Would would be difficult to convince them that he's not guilty. 51% in Latah and 56 in Ada, and believe he should be sentenced to death. 52% in Latah, 49% in Ada. It's a high number. Should it be moved? Where? And there's a high prejudgment, but there are 16 times more people in Ada County who haven't prejudged. Whether it should move depends on the totality of the findings. And then more survey responses, percentage of people who talked about the case online or in person, 79% in Latah and 60% in Ada. Seeing something on social media, 38% in Latah, 29% in Ada. Watch an episode or show on the murders, 32% in Latah, 23% in Ada. Experience higher levels of stress, anxiety, or fear, 39% in Latah, 17% in Ada. And know someone who experienced high levels of stress, anxiety, or fear, 45% of Latah and 24% in Ada. So people were afraid to go places and lock their doors for the first time. So, lived or know someone who lived in Moscow at the time, 78% in Latah, 4% in Ada. Walked by the home where the murders occurred 40% in Latah, 8% in Ada. Familiar with 5 or more of the 9 media items, 79% in Latah, 65% in Ada. Familiar with 7 or more of the 9 media items, 52% in Latah and 42% in Ada. And he doesn't test every possible term. He reads coverage from local newspapers and selects things referenced multiple times, things that might be inadmissible, etc. So he kind of breaks it down in Latah County. 98% recognized the case, 97% recognized it after the first case recognition question, 29% followed the case very closely, and 38.5 followed it somewhat closely. 84.2% of people who follow it closely believe he's guilty. 77.2 who follow it somewhat closely believe he's guilty. 88% of prospective jurors who knew about the case have talked about it or heard others talking about it. So that's a huge, huge percentage of population that knows way too much about the case coming in. Because that just creates a situation where you're trying to solve this issue on voir dire. And I agree with the previous expert. People can say whatever, and the bar is so low for a judge to consider a juror rehabilitated with respect to them saying that they have formed a bias. Like we've had it where they've come flat out, prospective jurors saying, yeah, we're biased. We've heard about it. Yeah, we kind of think they're guilty. And the judge says, okay, well, can you put that aside and can you follow the law? And if they say yes, many times the judge would consider them to be rehabilitated, which is absurd. It's just not a thing. But that's how our system works. So there were obvious rumors that were floating around that Kohberger committed a murder in Oregon, that the boyfriend and girlfriend weren't supposed to be there. Kohberger wrote about wanting to commit the perfect murder. He committed the murder to see if he could get away with it. Hates women, doesn't respect them, had trouble working with women at the university, stalked one of the victims, etc. Those were all out in the media or social media, one of the two. Some responses to the questions about how the crime affected the community. It shattered their sense of innocence, which obviously would happen, certainly. They had an idyllic community and this guy destroyed it, and they had a safe community and now that's lost. So those are all biases. Those are all things that, even when you're sitting in the jury box and not thinking those things, you're concerned as an attorney that's trying the case that just is sitting there in your subconscious. It's like something that you think and believe, and that's going to cause you to swing one way or the other. And in this case, it would be, in favor of the state, despite what you're hearing evidence wise. I mean, that's always what the concern is in these cases. We're humans. We have emotions. We care about things, and they affect the way we think about things. So it's like we do the best we can during voir dire to select jurors that are, they call them a blank slate here. I call them like a blank canvas or just, unformed clay, that you can mold with the facts and The evidence at trial, that's what both sides are supposed to want. I mean, prosecutors always say they want that. Defense attorneys definitely want it. Um, so then prospective jurors developed a detailed knowledge structure about the case because of their exposure to the media. The more case knowledge you have, the more likely you are to believe he's guilty. So 80.6% knew the police found a knife sheath on the bed next to one of the victims. 67.3% knew the DNA on the sheath was matched to Kohberger. 86% know he drives a similar car. 44% believe he stalked one of the victims. 45% believe he followed a victim on social media. So numbers are lower in counties where the population is larger. There's also a big difference in the number of people with personal connections to the case. It's much lower. Um, for instance, in Ada, the population 18 and older is 406,068 people. Latah, 18 and older, 32,515. So you can't rehabilitate a juror because they will just give socially acceptable answers about how putting aside their bias, but people can't just forget everything that they know, which is what I just said. They discuss the possibility of stealth jurors who want to be on the case. It's always a possibility. It's always a fear in high profile cases. Um, Testified to more on recall and recognition. You can't remember everything you've read, seen, or heard about a case, but people will remember when prompted on specific details. In a study, people reported hearing 1.6 details, but 96% were unable to recall at least one media item. And on average, people recognized an additional 4.9 items. So people know a lot more than they can recall. And the media items that they're talking about are the specific things that they told them about in the questioning. So they gave 9 different items, which I didn't go through because I think they go through it in the order here. So this is it. Can you set it aside and be fair and impartial? The dreaded question, the dreaded rehabilitation question that I was just talking about. There's no data to suggest that this is a valid question. It's not valid. One study went to the Facebook page for the Jinx and recruited people who made extreme comments online about Durst's guilt. When asked if they could set their opinion aside and be impartial, 81% said yes. If you saw that in a courtroom, you'd think those jurors were rehabilitated. It's not the case. And then final opinion. So the final opinions: Latah County is a very small venue. Crime is seared in public consciousness. Most prospective jurors in the county have direct or indirect connections to this crime. These murders created fear and panic in Latah County. Rumors and misinformation spread throughout the community, and a Latah jury will feel community pressure to convict. Latah County jurors have closely followed the case, talked about the case, and are familiar with many prejudicial details reported by the media. Presumption of innocence undermined. Presumption of guilt prevails. Pre-existing attitudes and opinions are likely to impact how jurors evaluate witnesses' testimony and evidence. The defendant has to prove innocence and change jurors' minds. For dear, not an effective remedy in this case for identifying and ferreting out bias. And a change of venue is recommended to protect the defendant's due process rights. The state did not cross-examine him. Defense then called Dr. Veronica DeHeer, and she works at the University of Nevada, Reno. She testified as a consultant. And in terms of what she does, she heads the survey lab at the university. She researches the judicial system. She's extremely qualified. Dr. DeHeer designs and critiques surveys and has published research on different aspects of survey research. So on direct, Ms. Taylor asked, there are best practice guidelines, and Dr. DeHeer is familiar with them. Taylor asked, why do people do surveys? And she answered, to gain information on various populations, needs, attitudes, etc. There are many reasons in the criminal justice system, such as making or reforming policy, importantly, to assess the impact of pretrial publicity, many other reasons. And she reviewed Dr. Edelman's survey. In my opinion, it was a valid survey. And then many things go into the survey: validity and reliability. Here, content validity validity, construct validity, measurement reliability, response reliability, etc. And then questions from the state, there were none. And then it ended with the state and the defense arguing. Taylor argued that pretrial publicity has impacted Kohberger's ability to receive a fair trial in Latah County. Points to the amount and type of media coverage. The survey shows it actually prejudiced potential jurors. She talks about the size of the community, the people connected to the case and the university, the pervasive negative coverage, and the lack of any positive coverage. There's less coverage in other parts of the state. Says jurors won't feel comfortable or safe. Asks the judge to move the trial to Ada County. And then the state, Ingrid Beatty argued for the state, and she argued that the law does not support a change of venue. Talks about how for 6 months, Ada County had more coverage. Says that there's media coverage everywhere and thinks that coverage in Ada County will overtake coverage in Latah County. Mentions that the survey's 5% margin of error and says that other communities surveyed are within that margin. Latah had the highest percentage of respondents who didn't have an opinion on Kohberger. Says the state would engage in good faith discussions to address concerns such as allowing potential jurors to have individual voir dire out of the presence of the cameras, suggest closing upcoming hearings, motions, or briefs. The court says the voir dire is the appropriate process. We don't get to burn the system down. And Beatty wants to bring in 1,800 eligible potential jurors to seat a jury of 12 with 6 alternates. So that's 1,800 out of 32,000. She goes through various survey questions and estimates how many people in that 1,800 pool wouldn't have bias. Asks the judge to consider Nez Perce County if he's inclined to move the trial. She doesn't want to transport evidence for 3 months and brings up many logistical concerns. Tells the judge that Latah County is made to expand and contract because it's a college town and can handle large influxes of people. It's more convenient for the victims' families to stay in Latah. Asks the judge to deny the motion. And then Taylor gives a rebuttal. And then Judge at the end said, professionally, this is one of the most difficult decisions I have to make. Both sides related solid positions on practical and logistical concerns and prejudicial media. I'm going to go through everything, go through the law again, the rule itself and the interpretation. I listened carefully all day. I have work ahead of me. And then that ended that. So thank you for that, Spot. It was great. I loved it. The Spitfire just crushed it. All right, so I'm going to pull up the order that came down so y'all can take a peek at it. I think this is the one. Share that out. Blow it up. All right. Okay. Oh, yeah, I did. I read. To be honest with you, Spit, I jump right to the analysis. I like as a lawyer, I never read the background and that stuff. It's just, that's the force of habit. I'm getting to the nitty gritty. I don't need because typically they're my cases. So I typically don't need to read all the filler stuff because remember, all these motions and orders are written with the appellate court in mind. So they've got to put all this stuff in here that, is going to be considered by the appellate court, and they want to give them factual background. All right. So it's a lengthy order. I'm going to kind of whip through the beginning. As Spitfire just said, much of it was contained within this itself. So as we can see, the hearing was heard on the 29th of August, 2024. Tell us who the witnesses were. The state did not call any witnesses. The court has spent many months carefully considering the legal and logistical concerns with the trial of this length and magnitude, carefully reading each submission, listening to each expert, and evaluating each party's position. And he tells us right here, based on the totality of the factors, defendant's motion for a change of venue is granted. It's moving out of Latah. So this gives us the background in terms of the case, which we went through. We're not going to go through it again. uh, I'll pick and choose some things to read because of the extensive media coverage from the outset of the homicides. A non-dissemination order was also quickly put into place by stipulation of the parties on January 3rd of 2023 to help protect Kohberger's rights to a fair trial by an impartial jury. The non-dissemination order, as amended, has remained in place throughout the duration of this case. An additional effort to help Kohberger's right to a fair trial on November 17th of 2023, the court entered an order removing cameras from the courtroom. Since that time, the proceedings have been streamed via court's YouTube channel, which in theory allows the public to access the proceedings while minimizing judicial photographs and videos focusing solely on Kohberger and his every move. So despite efforts by the parties and the court to protect the jury pool, excuse me, from being inundated with information that is potentially prejudicial and false, extensive media coverage by mainstream media sources such as newspapers, radio stations, and television news outlets has continued throughout the state and nationally. Additionally, and perhaps more challenging, is the ongoing spread of prejudicial misinformation, rumors, and patently false theories of the case on social outlets such as Facebook, podcasts, and blogs. There have been numerous television shows and documentaries produced about the homicides, and at least one book has already been published. So the parties agree, obviously, that the case has generated extensive coverage by the media, internet sleuths, and others trying to capitalize on the tragedy, but disagree on how the court should attempt to remedy the issue to ensure Kohberger is tried by a fair, impartial jury. In sum, Kohberger argues that venue must be changed from Latah County to a location with a larger population that is geographically distant from where the homicides occurred. The state asserts that a larger jury pool, extensive juror questionnaires, and voir dire are sufficient remedies that will result in a fair and impartial jury in Latah. We know that he didn't agree with that. So then he goes through the evidence, and again, that was James Todd Murphy from True Scope. He gives all his deets there, and then Dr. Alali. Is that it? Am I saying it right? Spitfire will know. Alali. So she gave her testimony, which was pretty compelling as well. And then Brian Edelman gave his testimony. He gave the results of the survey, which were pretty damning in terms of trying to keep it in that county. And then Dahir, and then the media article and video clips. So the defense also submitted numerous media articles and video clips demonstrating the sheer volume of coverage this case has generated. The court agrees, and the state does not dispute, that the coverage of this case by both mainstream media and social media outlets has been extensive in Latah County, throughout Idaho, and nationally. So while some of the mainstream reporting has been appropriate and based on information from the court record, there has been appropriate and based on information from the court record. There has been an extensive coverage that is prejudicial to Kohberger and likely inadmissible at trial. So this is the standard that the judge applies when ruling. Okay, and both the Idaho Constitution and the U.S. Constitution protect a defendant's right to a fair trial by an impartial jury. To help achieve a constitutionally sound trial, Idaho Criminal Rule 21 allows transfer of a case for trial in certain circumstances, or instances rather. Idaho Criminal Rule 21A states that, quote, on motion of either party, the court must transfer the proceeding to another county if the court is satisfied that a fair and impartial trial cannot be held in the county where the case is pending, end quote. Similarly, Idaho Code 19-1801 states that, quote, a criminal action prosecuted by indictment may be removed from the court in which it is pending on the application of the defendant on the ground that a fair and impartial trial cannot be had in the county where the indictment is pending, end quote. So the Idaho Crim Rule 21 also allows a transfer convenience for convenience. On motion of the defendant, the court may transfer the proceeding to another county for the convenience of the parties and witnesses and in the interest of justice. So a motion for change of venue pursuant to Idaho Criminal Rule 21 is left to the discretion of the trial court. And that came down through State v. Haddon. So the analysis. So this is where he breaks it down. So he cites the law that he's going to be applying, and then he analyzes it. And I'm not going to bring up other cases or other judges, but like these are just the kind of orders that you want to see in big cases. Like you want a judge spending time putting together an order where you know that they've spent time thinking about it, where you know that they've spent time evaluating the evidence that they've heard and seen, and then putting it to paper for everyone to read and giving us the rationale why they decided a certain way. And, in certain cases that doesn't happen, and it should. Instead we get long-winded orders that are minute orders and not full 20-page orders that really get to the heart of the issue. So number one, prejudice. Deciding a motion for change of venue, quote, the court determines whether in the totality of the circumstances juror exposure to pretrial publicity will result in a trial that is not fundamentally fair. The critical inquiry is whether the nature of their exposure to pretrial publicity caused the prospective juror to form an opinion about the defendant's guilt, and as a result, they're unable to serve as an unbiased juror. In determining whether a criminal defendant actually received a fair trial, the Idaho Supreme Court considered the following factors. One, the existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place. Two, the testimony of the jurors at jury selection regarding whether they had formed an opinion based on adverse pretrial publicity. Three, whether the defendant challenged for cause any of the jurors finally selected. Four, the nature and content of the pretrial publicity. And remember, you can the difference if you guys don't challenging for cause is where you're basically saying to the judge, look, I don't have to use any of our preemptory challenges. You get preemptory challenges, each side gets a certain amount of challenges. And if there's a juror that you want to cut, you can use your challenge. If they come across as having bias that's irreparable, or they give an answer that shows some kind of other bias that just won't allow for them to serve on the jury, you can always ask the judge to remove them for cause. That's ultimately going to be the judge's call. If the judge does remove them for cause, then that doesn't use up one of your challenges. So you like to try to keep your challenges because, picking a jury is such an art, and it's really, in my estimation, the most critical part of the entire trial is picking that jury, because you're doing the best that you can to try to, weed out people that are just coming in with a predisposition of anything, especially guilt. You just want them to be able to sit there without having formed an opinion prior to, and just hear all the evidence and just rule on it from what they heard at trial. And that's it. That's perfect world. That, in a high profile case, it rarely happens, and and as you know, from following this channel, once you are convicted, undoing that, it's a thing. It's very, very difficult to do. Some of these factors can only be evaluated during or after jury selection, while others can be evaluated by the trial court in deciding an earlier motion to change venue. So A, actual prejudice. In evaluating actual juror prejudice, the relevant question is not whether the community remembered the case, but whether the jurors at trial had such fixed opinions that they would not judge impartiality uh, or judge impartially the guilt of the defendant. Stated differently, courts must evaluate whether, quote, in the totality of the existing circumstances, juror exposure to pretrial publicity resulted in a trial that was not fundamentally fair. The defendant bears the burden of proving prejudice or showing a reasonable likelihood that there was prejudice. So, in reviewing case law, and it's funny when we polled citizens in Douglas County for that Garcia case, and uh, when Allison got the hit from the ARDC for making the pretrial statement talking about the DNA, which we're getting to in the Garcia thing. One of the things that the ARDC was bitching about was the fact that we did a poll, and I'm like, what? Yeah, like, how are we supposed to prove that the community at large has a bias against the client without doing a poll? We were supposed to guess. It's really weird. It was strange. It never went anywhere, but I was stunned that they brought it up. Um, in reviewing case law, a finding of actual juror prejudice rests on an examination of the jury selection process. This includes evaluating how jurors answered screening questionnaires, the testimony during voir dire of the veneer as a whole, and the jurors eventually seated, and any jurors seated despite a for-cause challenge for the defense or by the defense. Um, in reviewing a trial court's decision denying a change of venue motion, the Idaho Supreme Court considers, quote, the testimony of jurors at jury selection regarding whether they had formed an opinion based upon adverse pretrial publicity, whether the defendant challenged for cause any of the jurors finally selected. These factors are considered along with evaluating the pretrial publicity itself and the timing of the publicity. Here, the defense argues that the survey work of Dr. Edelman establishes actual prejudice within Latah County. However, actual prejudice cannot be evaluated at this juncture based on a survey of some 400 Latah County residents who are anonymous, did not answer questions in court, and were not subjected to questioning by the state, or were not subject to questioning by the state. Without attempting to seat a jury, there is no real evidence, such as juror screening questionnaires and testimony during voir dire, for this court to evaluate actual prejudice. So the court kind of rejected that notion. And then presumed prejudice. So adverse pretrial publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. That came from Patton versus Yount. However, a presumption of prejudice attends only the extreme case, and juror exposure to news accounts of the crime alone does not presumptively deprive the defendant of due process. And that's Skillings. So publicity by itself does not require a change of venue. Indeed, prominence does not necessarily produce prejudice, and juror impartiality does not require ignorance. Italics and original, he states. Unlike with actual prejudice, a finding of presumed prejudice means that the court need not consider jury screening questionnaires or testimony during voir dire before declaring a jury verdict void, or in this case, declaring a change of venue appropriate based on prejudice. It is the defendant's burden to establish, quote, a reasonable likelihood that prejudicial news coverage prevented or will prevent a fair trial in violation of the Sixth Amendment to the United States Constitution. This is not an unreasonably high hurdle for the defendant to clear. In cases where juror prejudice has been presumed, the following factors have been examined. One, the size and characteristics of the community in which the crime occurred. Two, whether news stories contained a confession other than blatantly prejudicial information of the type readers or viewers could not reasonably be expected to shut from sight. Three, the lapse of time between the prejudicial news coverage and trial. And four, what the jury actually found as far as guilt is concerned, i.e., was the defendant acquitted of some charges? And that again comes from Skilling. In Idaho courts, In Idaho, courts consider one, the existence of affidavits indicating prejudice or an absence of prejudice in the community where the trial took place. Two, the nature and content of the pretrial publicity. Three, the amount of time elapsed between the pretrial publicity and the trial. And then when reviewing the nature and content of the pretrial publicity, the trial court should be concerned with the accuracy of the pretrial publicity, the extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, and the number of articles where the jurors were so incessantly exposed to such articles that they had subtly um, become conditioned to accept a particular version of the facts at trial. First, as to the size and characteristics of the community, Latah County is a relatively small community with a population of approximately 41,000. 24,963 who are eligible to serve on a jury. The state argues that this is enough to impanel 18 impartial individuals. Defense argues that the small, tight knit community makes it impossible to find impartial individuals because of the extensive publicity in Latah County residents have been exposed to, the emotional experience and feelings of fear that residents experienced in the wake of the homicides, feelings of loyalty to the community, and community connections. The defense's position is supported by the testimony of Todd Murphy, Dr. El Alaye, Alaye, Alele, that seems right, Alele, and Dr. Edelman. As Mr. Murphy testified, 36% of all mainstream news coverage of this case throughout Idaho has been in Latah County. This, coupled with the smaller population in Latah County, makes the probability of Latah County residents' exposure to such coverage higher than in Ada County, Bannock County, or Canyon County. Dr. L. Aleli, I'm going to go with that one. I think Aleli is right. Testified that the more publicity one is exposed to, the more likely an individual is to dislike Kohberger and view him as guilty. Or while Dr. Edelman's survey results suggest that similar percentages of survey respondents throughout the counties surveyed knew of the case and presumed Kohberger was guilty, the sheer number of individuals in the larger counties increases the chances of impaneling a fair and impartial jury. Further, both Dr. E, that's what I'm going to call her. No, I'll say her whole name. L. Aleli. I just always want to try to pronounce names right. It's a weird thing with me. El Aleli. Dr. Edelman expressed great concern over the emotional experiences, feelings of fear, and personal connections of Latah County residents. These issues are unique to Latah County and are exacerbated by the small size of the community. Potential jurors in Ada County, for example, did not experience the same level of fear caused by the homicides at Latah County as Latah County residents. Similarly, it is far more likely for jurors in Latah County to know someone involved in the investigation of the case or otherwise related to the case, and more likely that Latah County residents have discussed the case with each other. Additionally, the smaller community makes it more difficult to keep the identity of the jurors private, which, as Dr. L. Aleli testified to, may hinder some jurors in their decision making because of feelings of loyalty to the community. Next, as discussed above, it is undisputed that there has been a significant amount of media coverage in this case throughout the state and nationally. While some of the coverage has been neutral reporting of the court proceedings, much of the coverage has been sensationalized and prejudicial to Kohberger. By way of example, the defense provided the court with 1,222 pages of news articles covering the case from one local newspaper. One article published after Kohberger's arrest includes statements from Washington State University students who reported feeling, quote, weird having sat in class with Kohberger and felt relieved knowing Kohberger had been arrested. Another article starts out by referring to Kohberger as, quote, the man accused of slaughtering 4 University of Idaho students, end quote. The title of yet another article refers to Kohberger as the U of I killer. While the issue of extensive sensationalized coverage is not unique to Latah County, it is potentially more impactful given the volume of coverage coupled with the smaller population. As to the lapse of time between coverage and trial, The information provided by Mr. Murphy demonstrates that coverage has overall waned since February of 2023. However, there is an uptick in coverage before and after hearings and court decisions. This is especially true for Latah County and with Ada County following a similar trajectory. The court does not anticipate this trend will change leading up to trial and anticipates the coverage will substantially increase in the weeks and days before the start of the trial. Finally, while this court does not have affidavits demonstrating prejudice in Latah County, the court must consider the results of the survey Dr. Edelman prepared. Again, while the presumption of guilt was similar across all the counties surveyed, number is far more impactful or is more impactful in Latah County given the smaller population. Some 67% of Latah County survey respondents reported believing Kohberger is guilty, with 51% of those indicating it would be hard for Kohberger to convince them of his innocence. While a similar percentage answered these questions the same in Ada County, the impact of these numbers when considering population size are drastically different. Latah County has approximately 24,000 residents who are eligible for jury service. If 50% of those are disqualified for having fixed opinions as to Kohberger's guilt, only 12,000 individuals remain. This is before any have been excused for hardships such as illness, breastfeeding, loss of wages for a 3-month-long trial, sole child care provider for young children, etc. Thus, when considering the prejudice in Latah County demonstrated in Dr. Edelman's survey and the population size of Latah County together, the court is concerned that if venue is not changed now, it will be asked to reconsider its decision during jury selection, which, if granted at that juncture, would very likely result in the trial being delayed for many months. It's got a very valid point there. It's very valid. I'm a little curious as to why they didn't seek to for a change of veneer like they're doing in Richard Allen's case, wherein they are picking a jury in Allen County. They're going to actually pick it up there, and then they're going to bring them back and sequester them probably in a hotel in Lafayette for the pendency of that trial. They're not going to have them driving back and forth every day. It would be crazy. Because that saves all the cost and time in terms of moving everything, in terms of all of the evidence, the staff, everything that would have to move in terms of trying to get that thing switched to a different county. I'm surprised they didn't do that, to be honest with you. It's kind of a trend now to do that, just import juries from different counties as opposed to moving the whole trial somewhere else. Considering the undisputed evidence presented by the defense, the extreme nature of the news coverage in the case, and the smaller population in Latah County, the defense has met the rather low standard of demonstrating a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. And then there's convenience in the interest of justice. Even without a finding of presumed prejudice, venue in this case must be changed, quote, for the convenience of the parties, witnesses, and the interest of justice. While this issue was summarily addressed by the parties, the court has considered the logistics while the motion for change of venue was pending. While Latah County court staff and court security are ready and willing to facilitate this trial to the best of their ability, there are serious issues that cannot be resolved no matter how much planning and preparation is done. First, and perhaps most important, is the issue of safety and security for the parties, the witnesses, the victims' families, the jurors, and the Latah County community itself. The Latah County Sheriff's Office, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial while also continuing to perform their day-to-day duties of patrol and responding to calls. One solution is to ask the Idaho State Police, Freudian slip, and the Moscow Police Department to help. However, officers from both ISP and MPD were heavily involved with investigating the homicides, and it is anticipated that several officers will be called to testify at trial. Additionally, it is the court's understanding that both of those agencies are currently understaffed. Pulling local officers away from their normal duties for 3 months to provide trial security would potentially put the Latah County community at risk. Further, in the event of a natural disaster such as a wildfire or a large emergency like an active shooter or multi-vehicle wreck, there's a very real possibility that officers tasked with trial security would be pulled away to deal with other issues. Thus, while our law enforcement is ready and willing to do what they need to do to ensure a safe trial, there are not enough officers to ensure the safety of the parties, the witnesses, victims' families, the jurors, and the community for a 3-month period. Similarly, Latah County does not have enough court clerks to efficiently manage the jury selection process. It is anticipated that general qualification questions will need to be sent out to some 6,000 individuals. Wow, that's a massive amount. The court clerk, the court clerks will be tasked with then entering juror information from those 6,000 individuals into an electronic system. This task alone will require several clerks and will take time. Yeah, a lot of time. Latah County has only one clerk currently familiar with the process, and she has several other day-to-day responsibilities outside of her role as jury commissioner. Thus, to accomplish this task, Latah County would have to bring in clerks from other counties to help, along with extra computer equipment for those clerks to perform their work. After the initial process, the court would summon in some 1,800 individuals to fill out extensive jury questionnaires. Again, this process will require both court clerks, and court security to take attendance, manage and move individuals where they need to go to fill out questionnaires in privacy, scan questionnaires, and quickly get the questionnaires to the court and counsel. Again, while Latah County court staff are willing to do what needs to be done, the reality is that we do not have enough individuals to perform the task of jury selection effectively and efficiently. Further, the Latah County courthouse itself poses significant issues for a trial of this length and magnitude. The courthouse lacks the space needed by both the state and the defense, while the state has a dedicated space within the courthouse. The state would still be faced with the challenge of escorting sensitive witnesses through public spaces in the courthouse to get to the courtroom. Meanwhile, the defense does not have the dedicated space within the courthouse, and there are limited options available. The few options available, i.e., the district court meeting room or a pretrial room, are small, located in public areas, and are not soundproof. These locations do not provide the defense with the privacy it needs during trial to meet with each other and witnesses. Further, the jury room itself is problematic in terms of its size. Fitting 12 to 13 jurors in the room for a routine trial is crowded. Fitting 18 jurors in the jury room for 3 months would be uncomfortable at best. Additionally, the door between the jury room and the courtroom is not soundproof. Further, court security would be tasked with trying to bring the jury into the courthouse in a fashion that ensured the jurors' privacy while also ensuring the court's privacy. The only options for bringing the jury into the courtroom is through the public hallways or directly past the court chambers. Neither are good options. Further, there is the issue of the continuing day-to-day operations of the Latah County Courthouse. The magistrate judge will continue to have daily hearings. A district judge will continue with the day-to-day operations of the district court, and the juvenile and CPS caseloads will have to continue. Additionally, the clerk's office must continue with its day-to-day operations of processing case filings, taking payments, and assisting the public. All of these normal court operations will undoubtedly be strained by the resources required for this trial in terms of space and personnel. So, while traveling to another county for 3 months is indeed inconvenient for the attorneys, the court, some family members of the victims, and some witnesses, having the trial at Latah County Courthouse would also be inconvenient in numerous ways, and beyond that, would present serious safety risks. Thus, the interests of justice require that the trial be moved to a venue with the resources, both in terms of personal and space, necessary to effectively and efficiently handle a trial of this magnitude and length, so that the parties in the court can focus on the case and not the peripheral issues. Conclusion in order. Kohberger's motion to change venue is granted pursuant to Idaho Criminal Rule 21A and 21B. Consistent with the language of Idaho Criminal Rule 21C2B, this court orders a transfer of venue, quote, without specifying the new place of venue, and, quote, refers to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another judicial district and assignment of a specific judge to preside in the criminal proceeding. And motion. That's it. So yeah, it was I was I was pretty I wasn't shocked, but I was surprised. I was shocked, but I was not like, I don't know. Like I yeah, I wasn't shocked, but I was surprised. Like I thought that he might do it. I thought that he needed to do it. Like that county, like it's just too small. Like this case, it's worse than, it's like 100 times worse, maybe 1,000 times worse than the Richard Allen thing. Like that case, like pre-arrest was insane, and then after like just the whole world was good, was like on fire with that case. It was crazy. So there's no way that that community just wasn't inundated with it. Um, so I don't know. I don't know. It was what really like did shock me is the case that um Judge is off the case now. He's off of it. So like for anybody who's not clear on that, he is not going to be the judge any further, which is a big deal. I mean, he has heard a lot of the pretrial motions. He's made a lot of rulings here, and it's a big deal whenever you get a new judge in the middle of a case. That means a new judge is going to have to really dig into the case. I mean, the judge has to look at prior rulings. Like they just can't come into the case and say, "Oh, let's go. We're ready to go." No, it doesn't work like that. They have to, because all the rulings that were made previously are relative to the trial itself. Like those are the things that they have to abide by, the previous rulings by another judge in terms of what's admissible, what's inadmissible. Um, hey, what's up, Brandy? Thanks for hanging, girl. We were bragging on you today. I was telling the story about how I text you to go up and ask the the court clerk real sweetly, "Oh, could you remind the witness to speak into the mic?" And like 3 minutes later, it happened. But it was either like the debate was like Tracy K, one of our mods, was emailing the court, and like I asked you to do that at the same time. So we didn't know who it was. We didn't know who it was. But you were definitely, we loved having your boots on the ground. So thanks for giving us the intel. And by the way, um, Brandy just got like some inside baseball video of, and I'm pivoting very quickly to the Shaver case of her marriage to her current husband that happened in the backyard, and you can see the fire pit there. So that's wild. So make sure you're going over there and checking out her channels. I'm sure she's got it up. Or I think she just put like a little teaser up there. I'm sure she's gonna do a full live with it. So make sure you're subbing over at Brandy's spot. Um, so I mean, what do you guys think? I'm gonna like what I want to do. Like I just think it's like I was shocked that Judge is off the case by his own doing. Like I pulled it up. I was tweeting about it today. I know some of you guys don't do with the Twitters. I don't blame you. God, it's so hateful in there. It's just insane. It's insane. And I never fire back. It's like people calling me names, and like it's just coming at me. And I just try to keep it professional, like, what am I gonna do? What am I gonna do? Like I just need to start blocking people. That's what I have to start doing. Like I took great pride in not blocking people, because I really do like to hear the other side on everything. But when people just start abusing you on there, it's like, dude, come on. It's like your people aren't involved in this case. Take a breath, bro. Relax. Calm down. All right. So, but I do want to pull something up, which is so I want to be clear because when I first put up the fact that he had ruled, because I saw like maybe Court TV was the first person I saw to post on it. I had just gotten the email from Nate, who's the guy who handles he's the guy in Idaho that is really handling all the media stuff. So like we're on the list. So anything that comes down, he emails it out to the list right away. So we get it right away. Um, so when I read it, I'm like, oh, I'm like, yeah, they definitely yeah, okay. So they definitely are transferring the trial, but Judge is off this case. And I'm like, I read it a bunch of times. I'm like, I don't want to be inaccurate on this because like people really scald me for screwing that up, So I wanted to make sure. So I'm rereading it. I'm going to the rule. I'm like, all right, like he's out. He's out. All right. So I want to bring this thing up, which is the actual rules. This is how I was able to figure it out. It felt very secure. I honestly think I was the first one reporting on him like being done. So this is the Idaho Criminal Rule 21, which he refers to. Okay. Um, and this kind of breaks it down for us. And this is uh transfer trial. So a motion to transfer may be made at or before arraignment or at any other time the court or these rules prescribe. So A is for prejudice, which he went through these two, right? So for prejudice on the motion of either party, the court may transfer the proceeding to another county if the court is satisfied that a fair and impartial trial cannot be had in the county where the case is pending. Or B, for convenience. On the motion of the defendant, the court may transfer the proceeding to another county for the convenience of parties and witnesses and in the interest of justice. And then C is the proceedings on transfer. So C1 is transfer within a judicial district. If the proceeding is transferred to a court, proper venue within the same judicial district, the judge granting the transfer must A, order the case transferred to a specific court of proper venue within the judicial district, and B, continue the assignment over the case, unless the administrative district judge reassigns the case to another judge of the judicial district. So that's not what the one they were going under to. They were going under C2, C2A and B. Okay. So this is where I was at. I'm like, okay, so C2, which is transferred to a different judicial district, if the proceeding is transferred to a court of proper venue in a different judicial district, a new presiding judge is assigned as follows. A, if the original judge desires to continue the assignment over the case, the judge may so indicate in the order, which we know he did not do, suggesting a court of proper venue, which he did not do, and refer to the administrative director of the courts for assignment by the Supreme Court, which he did do, to a court of proper venue and for assignment of a specific judge to preside. Or B, which is this is the rule he cited, and then he put this language in his conclusion. So this is how I knew. I felt very secure once I read this. This is it. It's in stone. He's done. Judge is done. And that's B, if the original judge does not desire to continue the assignment over the case, the judge must enter an order transferring the case without specifying the new place of venue, and then refer the case to the administrative director of courts for assignment by the Supreme Court to a court of proper venue in another judicial district, and assignment of a specific judge to preside in the criminal proceeding, which is exactly what he did. He mirrored this language. So we know he's done. Like they're not going to appoint him. They're not going to make him go to wherever they move it. Judge is done. Now, as far as Judge goes, I consider it to be kind of a hit for the defense. Not because I thought he was biased for the defense, because I thought he was neutral. Like, that's all we ever ask for is attorneys trying cases. We want a neutral judge. I mean, would we love to have a judge that's biased for the defense? Yeah, of course. Of course I would. They don't exist. Like, I've never run into one. You never hear, oh yeah, that's a defense side judge. It's like you hear, oh, that's pro prosecution judge, because most of them are. A lot of them follow the prosecution uh, you know, trail up to the judge's bench, and it's factual. Many judges are pro state. That's just facts. It's part of the system. I mean, I'd be hard pressed to find any defense attorney, no matter who I bring on here, defense attorney wise, they will all give you the same answer because that's just factual. Majority of so all we can ask, knowing that, and if they're pro state, like I still just want them to be neutral and follow the law. That's all I can ask is be neutral and follow the law. If you do those two things, I don't care how pro state you are. If you follow the law, then I know you're on the up and up as a judge. And then I've got no beef. I got no, I mean, it's just that's how the system is. But if they're following the law and they're ruling pursuant to the law, like I mean, I can't have a beef. No defense attorney can have a beef with that at all. So I think it's pretty big news. I think it's pretty big news. Now, I don't know how long it's going to take them to figure it out. I had I took some heat on it. I was thinking, like, immediately I started thinking, who'd be a good judge for this is Judge Boyce, who sat on both Lori Vallow's case and Chad's case. I thought Boyce was a really good judge. Obviously, it's the same state. And then I put it out there and but he's in Fremont. So because they had a motion for change of venue in that case as well, they moved that to Boise, both cases, and he tried both of them, sat on both of them out of his county. I didn't realize how teeny Fremont was. Like Fremont's smaller than Latah. So there's no way that they're going to move it to somewhere smaller. But he would have been a great judge for it. Like that would have been the judge. Like if I was in the, administrative side of the Supreme Court, I would have put him back in. I'd have been thrown that name in the hat, because they're going to think about it. They're going to think about it. It's like, this isn't a normal case. You can't give it to a judge that is not ready to handle this case. You don't want a Judge Ito situation. Like he just lost control of the OJ case and it was ridiculous. Like the inmates were completely running the asylum in that case. It was a catastrophe in every single way. It was some of the worst judicial work I'd ever seen in my life. And at that point, I was in college, but I knew enough about the law. I'm like, oh my God, this guy's just it's lost control. So you need to have a judge that really knows what they're doing, is going to know how to handle the publicity that's going to come along with this. And a couple people asked me, am I sweating Judge for wanting to dip on this thing? No, I'm not. I gotta be honest. If I was a judge, I wouldn't want to touch this case with a 1,000,000-foot pole. All this can bring you is heartache, worry, concern, stress. It's just there's just so much peripheral crap going on with this case because of the national exposure. It's like when I say that this case, national media wise, dwarfs Richard Allen's case. I mean, it dwarfs it. It was night and day. This thing is I had not seen media coverage on a case like that since OJ. And I think that the only one that was close, the only two that I thought were even remotely as close were Scott Peterson and Casey Anthony. And they still weren't as big. Neither one of those was as big as this thing was. You could not turn on the TV anywhere and there wasn't something about this case on. And that's how OJ was. OJ was just so everywhere. It was prevalent, and that was the first trial that they ever broadcast like that, where the world got to see it. And got to watch it. Like that was the birth of court observation by the masses. And Ito just shit the bed, you know. So whatever the Idaho Supreme Court's going to do, they're going to be thoughtful about it. They're going to look at judges' records. They're going to look and see who's handled what, and they're going to look for judges that are going to be up to the task. You know, again, and I know I always like start talking about the Garcia thing, but like in that case, we had our judge after 2.5 years just dipped, just said he was, had medical problems and like dipped out of the case after he denied all of our motions, denied everything, our motion for change of venue, everything. Like everything that you're seeing here with the numbers was the same thing that was going on in Douglas County. The press was, it was more of a microcosm though, like outside of Omaha and maybe the Midwest, people weren't really hearing about the Anthony Garcia case quite as much. I mean, they've obviously done datelines and 2020s on it and stuff like that. But like at the time, it was, and I didn't care. All I cared about was the county that we were in and being able to get a fair jury in there. And, to this day, I don't think that we did. And we individually had to voir dire all of the potential jurors. Like one at a time in a conference room, closed off. It was unbelievable. It took forever. It was ridiculous. I don't know. I don't know. I kind of wondered that sometimes when I'd sit with them. He kind of had that vibe, but I think that was like he was old enough to where, back when I was coming up through grade school and stuff, like the spectrum wasn't a thing, you know. It wasn't something that had been recognized as an actual thing. So I don't know. Oh, I was looking at Dizzy's comment. So what do y'all think? You guys are there any questions I missed? I got some stuff in here. Charmaine, member for 11 months. Rock on. We love you. Aw, family hug. Big one. Big, long 11-month family. Aw, Gambies. So good to see you, girl. Woo woo. You'll have to put up with me for another 6 months. I love it. I love it. Put up, please. You are a welcome, loved, cherished member over here. Shiraz, love you. Gifted 10 DD memberships. You're the best. Appreciate you so much. So yeah, I think look, at the end of the day, this is the right call. I know that ultimately I feel pretty secure that the Supreme Court of Idaho will do its job. They'll find the right judge. And it's funny, like I've read from people I really respect, like lawyers, kind of their takes on judge, and I've seen varying opinions on how they thought he was handling the case. I saw people that were saying that they thought he was a little above his skis, that he was out of his element a bit, which in all fairness, I mean, to be honest with you, case like this, um, I mean, who's not going to be out of their element? Like you just like he's never had a case like this. I guarantee it. Like not with this type of publicity, not with like no one's had a case like this on the bench. So, I'm not sweating him on that. Um, I thought, I mean, whether or not he drafted this or it was his clerk, I don't know. I'm sure he had a clerk helping him draft it. And I'm talking about a legal clerk, not a court clerk. But uh, and I've seen people say that they thought that he was defense biased. And I'm like, you're just confusing the fact that he's neutral with him being defense biased. You're just so used to judges ruling in favor of the state that when they don't rule for everything in favor of the state, you're like, wow, this guy's a real defense judge. It's just a neutral judge who happened to be following the law. Is what it really is. So, I don't know. Um, so I don't know. I hope they get a competent judge. Um, and I hope that this guy gets a fair trial one way or another. I mean, I've got my thoughts on this case, and I've covered it pretty extensively in the early going, especially when the probable cause affidavit dropped. Um, I'm going to start picking it back up, especially if and when it goes to trial next year, and especially Nav the EO coming in hot with 50. You're what a champion. What a champion. What a champion human. Thank you so much. Well, 50 of y'all. You got good odds in here right now. I think you have to be in here to get the so out of the 150 in here, 50 of you are about to be. So I forget who was asking to be like somebody earlier today was like, make me one, make me one. You probably get there. So yeah, I just think yeah, I don't know. I don't know. Oh, the other news that I want to bring up, that I'm going to probably do a live tomorrow night, um, is that the defense in the Richard Allen case filed a motion to certify uh, the interlocutory appeal. Like they're trying to get it up for an interlocutory appeal in Indiana. The judge in this type of interlocutory appeal has to certify it. So it is now in Judge Cole's hands as to whether or not she will certify it. If she does certify it, that does not mean that it automatically is going to be accepted by the appellate court. The appellate court still has to accept it and take the issue under consideration. So, like, it's really a two-step process. If it makes it through Gall and then the appellate court decides to take it, I think that will ultimately result in a continuance because everything is stayed at the trial level while that's pending. So, which will be taken into consideration. We cannot pretend that is not one of the things that is going to be looked at by both Gull and by the appellate court if she certifies it. Like the real question becomes, and I'm not going to get into it. Yeah, interlocutory appeal, locatory, Lisa. It's with the different spelling. Oh, I would have no idea how often they're not certified defense. Like I have no clue. No clue. I'd have to go in and look at some kind of statistics. It's it's in the process is different in every jurisdiction and every state. So but like everybody's going to be looking at the concept of delaying trial, but they're also going to be weighing the concept of what the defense argued in their motion, which is if she erred, if she erred on a couple of things, which they're trying to bring up an appeal, which is the confessions, um, and then those being suppressed, and it was a novel argument. And I've heard other podcasts talking about how they didn't think the defense actually put an argument forth, but they did. It was a novel argument. It wasn't your typical in custody. They were browbeating the shit out of the guy until the guy just spilled. So it was involuntary in that sense. It's a much broader argument, but it's an argument in my world that has legs because I've actually been in cases on the defense side of it with people incarcerated in solitary for months, for years. And I mean, that is definitely a form of psychological torture. I mean, there's no other way to put it, So whether or not that is valid, and the other thing obviously was her denying them to put on a defense as far as a third party culprit. So those are the two issues they're trying to get up there. So what I was saying is like if they're of the mindset that either one of those two issues is weighty enough, problematic enough to where it's going to overcome harmless error and is going to be something that the court is going to say, nah, you screwed this one up. You're going to have to do it again. They're going to take that in consideration. I mean, like, I think the more likely of the two will be the third party culprit. I think that I don't know if the world's ready for Brad Rosie's argument. The, on his, on his, confession argument, but I think it was an excellent argument. I think it's a real argument. I think it's a legitimate argument. Like you have to like it's a broader scale, it's a broader scope than just in custody involuntariness. It's in custody where there's not a cop, you know, shining a bright light in your eyes and not feeding you for days. And like it's not that. It's like a constant wearing somebody down over months and months and months and really not having any idea of who's coming at him and who's coming at him with what in terms of things that they're saying to him, just getting in his head. It's like he couldn't even make that part of the argument because he doesn't know what's happening in there per se, unless he's got people that are willing to say what's what. But the broader argument, for those out there in the podcast world that think that that wasn't an argument or they didn't put forth any real argument, I would disagree strenuously. And we'll see. We'll see if it gets up. But I don't know if she'll like I look, none of us are gonna be surprised if she does not certify it, right? I mean, I'm gonna stay right there comfortably. I will comfortably predict she will not certify it. In which case, the question becomes, are they gonna ask for a continuance? Like he hinted at it. It was hinted in the motion, which I go through when I go through it tomorrow. You'll see because they're talking about, like McClellan has known about this thing since the first Franks came out. He knew that this was going to be their defense. Why are you waiting to like a month and a half before a trial to beef about it? Like what, like, why are you waiting until it's too late for the defense to make huge decisions and pivot to another defense theory? It's like, so I mean, that's like, it's a valid argument in terms of asking for a continuance. So it's like, whether or not they're going to do that is yet to be determined. I don't know. They might feel more comfortable with asking for a continuance now that uh, Allen's out of prison and now he's in Cass County Jail. I don't know. So, but we'll talk about that more tomorrow night. Tonight was a night for Kohberger case. So, all right, y'all. Tomorrow, bright and early. That's why I'm not hanging on here forever. I got to get up at the crack for day 2 of the Shaver trial. Had openings today. Had the first witness on. Sound sucked. So just beware. Wasn't me. Well, I did everything I could. The sound's just brutal. Like we've had cases where they've worked on it overnight where people are like, wow, the sound was really, really bad. So hopefully that happens. Hopefully they'll help us out with that and get some better sound going. Um, yeah, and I think that's it. So once again, Jennifer J25, so proud to be an OG of the Armada, and we are so proud to have you. We love you guys. Thank you, thank you, thank you. I think Chelsea became a new member earlier today. For some reason, it transfers some stuff over to the new live later in the night. But Chelsea, family hug. Charmaine, again, member for 11 months. Rock on. We love you. Gambies, we love you too. Shiraz, we love you too. Thank you so much for your constant, never ending generosity. It's amazing. And Nav the EO with the 50 all the time, like the 50 spot. It's incredible. Such an incredible show of support for this show and for the work that we do. Really means a lot to me because I put a lot of work into this. So to know that you guys care enough out there to give a little financial assistance is big. It is. It really is. It makes me feel loved. So I appreciate it always very, very much. And Lily B, Aw, family hug. Love that. Welcome. Welcome, welcome, welcome. And then defense, I wish I could answer that for you. You know who will probably be able to come up with that answer? Dizzy. She'll probably Dizzy will probably be able to I don't want to put any more on Dizzy's plate though. So Dizzy, don't you worry about that question. We'll just let that one hang out in the ether. We'll wait until she denies it. And then while everybody's rampaging, somebody's bound to put that fact up. Oh, oh, she's like 7 out of 10 are certified and gold didn't do it. It's like, well, yeah, ask around and let us know if you find an answer. It's like, I don't know. Like, I mean, are you talking about a specific judge or just in general? Like, it's like, I don't know. Oh, girl. Crutchy mama, tell me about it. Tell me about it. It's like, no one misses around here more than I do. Takes like the heat off me. You know how hard it is doing a hour and 40 live? It's tough. It's challenging. And I was on earlier today. It's a lot. I love having her, not just for her huge brain and beautiful looks, but just to have a partner in crime, just hanging with me, being my girl. It's the best. She's the best. And it makes for just good viewing for everyone. Everyone loves Allie. Every once in a while, somebody like, hey, I like when you're solo. You could just do all the reading and nobody's interrupting you. I'm like, well, I like it better when Allie's on with me. I appreciate that compliment, but I like it better when my girl's with me. So, especially because my boy is back on the rat race, back in the shit. We love him. We miss him. All right, you guys. You guys are awesome. Remember, come and hang. If you don't know anything about the Shaver trial, go and watch the primer we did on Friday. It's a crazy case with a lot of twists and turns. We got Brandy Churchwell, our friend over at 13th Juror, like just hanging in the courtroom. She's got all kinds of weird connections. Her bestie was super good friends with Shaver in college and like was over at her house, like at the fire pit, chilling, drinking beers. It's like, so Brandy's got some cool tales to tell. She's gonna be helping us out with some inside dope, even though she's running on her own channel because she's a homie. So give them love over there too. Sub over there, bounce back and forth, have us both on at the same time. It's all good because my girl Jessica for Justice is over there minding the shop while Brandy is boots on the ground. So look, takes a village. Takes a village to get through this crazy like true crime world we all love. Can't do it. We need all the peoples. We need all the peoples, and Brandy's definitely one of my people. So, all right, y'all, you guys are the best. I love you for the support, mods. Thank you for your double duty. To all my beautiful, wonderful mods, Tracy, Shiraz, Tiff, Diz. Who else is in here? Afton. Love y'all. Who else we got? Who else we got? Who am I missing? Who Law Nerd Amber? Welcome back, girl. We've been missing yous. Missy Mayhem. Always Missy Mayhem. I do not give Missy Mayhem like enough love because she is a ride or die here, rain or shine. I love you, Missy. Just know that. And I'm sorry I don't give you enough love. Just know in my heart that I mean it. You're amazing. Thank you so much. If there were any other mods that were in early and dipped, just know I love you all too. And for you guys out there, make sure, please, please, please. I've been stuck at like 23.5 for way too long. I got to figure out something to get the growth moving again. So you guys can help me with that. Please, please remember to like, share, subscribe. Helps get the show out to the algo. Once it gets out to the algo, I think we have good content. Maybe I'm wrong. I know I can be annoying at some points, but I think that there's also a lot of good information you get on this one. So I put her up there with CH, there you are. See, I kept looking. I knew there were other ones. CH, you too. Same goes. CH, Missy, y'all are all amazing. I love all of you guys. You guys are amazing. But please don't forget to share, subscribe, and like on your way out for this one. It really helps us grow. It really, really does. And think about becoming a member. I am going to start doing weekly members only lives the week after I get back from London. So I am back like the 28th of September. The next week, there's going to be, I'm starting to take care of the members. It's like that's in stone. I've got to start doing it. So our patrons and our members are going to get members only lives. Because I got to tease that out so that there's perks for y'all. I know that you guys that join as members do it to support the show, and I love you for it. I know what the main reason is, and it's because you're supporting the show. So I'm obviously incredibly grateful for that. But I want to give more to y'all because you're giving till it hurts. So I love you guys. Thank you so much because once again, without y'all, just an old man talking about a lot of cases. Talk to you tomorrow.